Thank you so much, everyone. Thank you to Wilma Liebman, to LERA, to our panelists, and all of you for making this discussion happen today. I'm Josh Eidelson, labor reporter for Bloomberg News and Business Week. I'll put my email in the chat so anyone who wants can get in touch about potential stories. 86 years ago this month, the New Deal Congress passed a then groundbreaking law guaranteeing US workers the right to protest, organize, and collectively bargain to change their workplaces, and creating a new agency, the National Labor Relations Board, to interpret that law and wield sole authority to punish violations of it. The NLRB was born controversial, and it's pretty much stayed that way ever since, with limits of its authority, its coverage, and its remedies hotly contested on all sides. With a new NLRB chair and acting general counsel named this year by a new president and a new Democratic majority expected in the coming months, we're here today to discuss what to expect from the agency, and we're fortunate to have a trio of very distinguished guests. Current NLRB chair, Lauren McFerran, is a former US Senate Labor Counsel who was named to the board by President Obama and made chair in January by President Biden. Marshall Babson served on the NLRB under President Reagan and today represents employers at the law firm Safars. Craig Becker served on the NLRB under President Obama and today is general counsel of the AFL-CIO. Please feel free to share thoughts and questions in the Zoom chat. Because time is limited, I've asked each of our panelists to keep their answers to each question under 5 minutes, beginning with this one. Starting with Lauren, then turning to Marshall, and then to Craig. What will and what should the NLRB do over the next few years? What will be the priorities to address? What approach will the coming Democratic majority take to determining who and what Section 7 protects?
Well, thank you very much for your participation here, Josh. It's very exciting to be part of such an esteemed panel. I'll try to do my best here. I guess if the question is what should the board do, I'll answer that question wearing my chair hat. The chair at the board, as most people are probably aware, is primarily an administrative type. I don't play any particular role in setting the agenda, for example, of what cases we hear. But I definitely do have some administrative priorities that I've brought to the chairmanship. Priority number one is staffing up the regions. The regions are not only the face of our agency, they are the lifeblood of our efforts to administer and enforce the act. I talk to people at lots of these conferences, or I used to when we had them in person, and I don't know anyone on either side of labor law practice who doesn't value tremendously the people in our field offices and the work that they do. In March, the GAO found that the NLRB staffing had decreased 26% over the past decade. Staff reductions were 4 times greater in the field offices where casework originates than in headquarters. And the staff reductions had outpaced declines in caseload. The report further found that during this period, the NLRB's appropriations decreased by about 17% when considering the effects of inflation. So this represents roughly about a $46 million decline in the agency's real purchasing power. Now, the president's budget request for fiscal year 2022 is a significant increase at $301.9 million, and the House actually put out an appropriations bill, I believe it was yesterday, that proposed an even higher number of $317 million. Even at the president's request level, that would represent about a 10% increase over the FY 2021 enacted budget, which would enable the funding of an additional 108 full-time equivalent employees in the field. Now, that's actually the minimum necessary to bring these frontline offices to the staffing levels that were recently mandated by Congress in the last omnibus appropriations bill. Congress has actually directly informed us that we have to staff up these offices to the FY 2019 levels at a minimum. So that the budget request is simply what we need to do in order to fulfill that mandate. Obviously, we would like to do more if we can. I think this would be, even at that level, it would be a tremendous development for the agency, though, that would really help our ability to fulfill our mission by putting people out there facing the public doing the work of the agency. the process of restaffing, to be clear, is already moving forward, actually, even with the resources that we have now. We're working on filling some senior and managerial positions that had been vacant for a long time. And we've already advertised, I think it's around 20 frontline positions in the field. We are getting huge interest in these positions, which is very exciting. But the hiring process, the federal hiring process, as most people know, takes some time. These additional resources would also give us the ability to address what I would say is my other really key priority as chair for the agency, which would be to revitalize our agency's outreach program. I'm very interested in increasing the agency's level of public engagement and accessibility. We can't serve our mission if people don't know we exist, or don't know what their rights are, or if they can't get the information they need from the agency, or can't easily figure out how to make use of the agency's resources. Our budget request would allow the agency to invest a little over $2 million in a comprehensive outreach program that would increase awareness of the agency and its mission, particularly among underserved communities, and would ensure that the public can easily access the guidance, the information, and the resources that they need from us. So I'm really looking forward to revitalizing the Public Affairs Office and to working with our talented technology staff to make some pretty significant improvements in those areas. So like I said, wearing my chair hat, I would say this is what I think one can expect from the Biden board, at least from an administrative and agency management perspective.
Marshall?
Well, again, let me just thank everybody for asking me to participate with this distinguished group. I consider Lauren and Craig to be colleagues and friends, and I appreciate the opportunity. Whatever differences we may have on policy issues from time to time, I think are eclipsed from by what we have in common. I would just like to second what Lauren indicated with regard to the agency. This has been a tough 4 years leading up to the Biden administration for the NLRB. And at the risk of sticking my neck out a wee bit, I would say this, and that is, which is not a small thing, I think. I say it respectfully, but I say it openly and freely. Whether you are an R or a D, if you do not believe in the agency and the mission of the agency, stay home. Don't take a position at the agency, wherever home may be. I don't have to name the particular state. It's very, very important. The agency has and can, to a certain extent, tolerate differences of view with regard to policy choices. We all know, for those of us who've done this for some period of time, that as one distinguished alum of the NLRB has said many times, there are many of these policy choices about which reasonable people may disagree. And I certainly understand that. And I think having a board comprised of experienced, practical practitioners, and I view the present nominees to fill that criterion is very, very important to helping make these policy choices. In terms of staffing up the agency, as the chair has suggested, that's of great importance. And for those of us, whether you represent employers, individuals, labor unions, all of us, I think, have had experience in the past several years of dealing with agency employees who are dedicated to the purposes of the statute, who work hard to fulfill the goals of the statute, but who have suffered real blows to their morale because of lack of support and lack of adequate manpower. So at the very, very least, staffing up, it seems to me, is important. This is of vital importance. I know we're going to discuss in more particular detail other initiatives related to this issue, but the agency simply cannot function if it's not properly staffed. And it's in everybody's interest. It's not in the employer's interest. It's not in union's interest, it's not an individual employee's interest to have cases that are not handled promptly and expeditiously. This is truly an extraordinary statute in many ways for the regime that it engenders. And this concept of collective bargaining, of creating a labor democracy in the workplace, is extremely important. I believe it's still important today, and I'm sure we'll talk about that a little bit more. But as to the chair's statements with regard to staffing up and reaching out, I say hear, hear.
Let me just jump in.
Sure, thank you. And Craig?
So first, let me thank Josh for being the MC, and let me thank LERA for hosting this, and just thank LERA in general. I'm one who believes in the facts and in data and in analysis. So all of you out there who are supplying that, I thank you. Then I just wanted to note the kind of unexpected timing of today's program. That is 2 days before the confirmation hearing of the two nominees, Gwen Wilcox and Dave Prouty. So I hope they're preparing for the expected question, which is, do you agree with any of the crazy things that the chair or Mr. Becker said today? But seriously, I want to make 3 points in relationship to Josh's question, focusing on the word should, since I obviously have no idea what the Biden board will do, but in terms of what they should do. I think the most important issue the board has to consider are what are the various ways in which the current board law furthers what we call the representation gap. That is the yawning gap between the number of people who wish to be represented and those people who manage to thread the needle of the board law to gain representation. Just to name a few examples, which are just vividly illustrated by the recent election at Amazon in Bessemer, Alabama. One, captive audience meetings. How can it be under a statute which says that people have a right to participate or not participate, that they can be forced to participate on pain of discharge? And again, multiple captive audience meetings preceding that election at Amazon. Two, the location of the election. Amazon was so desperate to hold the election on site, despite the pandemic raging in the county, that they actually convinced the United States Postal Service to put a mailbox essentially on site, despite the fact that it was a mail ballot election. Why? Because of the extraordinary advantages that the employer has as a party to the election when the election is held on site. And we could go on, but I think that's the key question. How does the board law further that representation gap, and what can the board do about it consistent with the statute? Secondly, while I think non-union protected concerted activity has a high symbolic value, I really wonder how much practical importance it has, even assuming the kind of public outreach that Lauren has described. That is, most people, as Lauren just said, don't know about their rights. And even when their rights are violated without representation, they don't know to go to the National Labor Relations Board. I think much more important, and that's my third point, are the restrictions on union activity that have a wholly extra statutory basis. Intermittent strikes, partial strikes and slowdowns, the unjustifiable restrictions on protest activity that have been drawn out of Jefferson Standard. So to reinvigorate not only the right to representation, but the right to accomplish something by representation, via protests and other kind of strike activity. I think those are the key issues for the Biden board.
Thank you very much, and congratulations to all the panelists on staying within time, a rare accomplishment. Before we move to another question, Chair McFerran, is there anything you'd like to say to respond to Marshall or Craig?
No, I certainly appreciate the articulation of support for the agency's frontline staff and the agency's resources. And I think we'll get a little bit later into kind of into some of the points that Craig was making a little bit more about, kind of PCA and union activity and things like that. So I'll save discussion on those topics for those subsequent questions. But I might have a slightly different perspective, but I absolutely appreciate everything that Craig said as well.
Thank you. Related to this, something that several of you brought up as we were preparing for this, and that comes up a lot in discussions of the NLRB, is this back and forth pendulum swinging on some of the same precedents each time that there's a new president and then eventually a new board and ultimately either a case or rulemaking that creates an opportunity. Is the back and forth pendulum swinging on the same issues something that's going to be with us forever at the NLRB? And in particular, are there new issues that the board will get to break ground on over the next several years?
Do you want me to start again?
Yes, please.
So the so-called pendulum swing at the board is perennially lamented. It is probably one of the most common questions I get asked about at these kinds of events. To some extent, it is just a reality of life. The act is subject to interpretation. People who were appointed to the board interpret it differently. And therefore, boards comprised of new appointees interpret the act differently than previous boards comprised of different appointees have done. To some extent, that kind of is what it is, so long as the process is set up the way it is. But obviously, I mean, to the extent that Congress thinks one interpretation of the law is preferable to another, to the extent that Congress wants the pendulum to swing in one particular direction, the best way to clarify that would be statutory change. I do think that greater public input and greater use of the regulatory process or amicus briefing and ways to get public input, at least in theory, could allow for greater stability in the law. It would certainly work better than the approach we've seen recently. One of my great criticisms of the current majority, and I must say that I have tremendous respect for my colleagues, and while we disagree, we disagree strongly, but I have tremendous respect for the work that they do. But one of my great criticisms of them is their tendency to change the law without seeking public input, and to use a single case to make sweeping changes to the law that went far beyond the issues necessary to decide the case, often without even letting the parties themselves know that comprehensive reversal of precedent was on the table. I think the most prominent example of this was probably the 2017 decision in Boeing involving handbook rules, where the majority didn't like the prior board's approach to handbook rules. They claimed that the Lutheran heritage test, which was the prior test, caused uncertainty and confusion. So rather than seeking input on different approaches that might create greater certainty, they used a case that involved a single no-camera rule to create an entirely new comprehensive categorization system for all workplace rules, without seeking any input from the millions of employers in this country that have handbooks or the tens of millions of employees in this country who are subject to them. The result, not shockingly perhaps, was a new test that, while it often led to the opposite outcome in individual cases, like the prior test, also created tremendous confusion and lack of stability. I think the better approach might have been to use amicus or to use the rulemaking process, or to use some sort of way for soliciting public input to really try to figure out what people's concerns were with the prior standard and how to address those concerns. I actually articulated several possible approaches in my Boeing dissent that I thought were worthy of consideration. But one thing I want to be clear about here, because like I said, I do get this question a lot, and it sometimes, I'll be candid, irritates me a little, because soliciting public input and public participation only has the potential to mitigate this pendulum swing if the people who do business before the board were to really hold stability as their highest goal, rather than just getting the outcome they want in more cases. Problems when a proposed rule is put up for comment or a case has been put out for amicus briefing or something like that, we don't get a lot of people all coming together to say, well, here's an approach that, while it wouldn't really give me everything I want, and it really wouldn't give the other side everything they want, it would provide for greater stability in the law. So let's mutually advocate for that and see if it sticks. People don't do that, because as much as they claim that they hate the pendulum swing and that they like stability, people advocate for the approach that benefits their side. So the pendulum swing will continue then, I guess, until and unless Congress tells us where they want the pendulum to fall.
Thank you. Marshall?
So this is an issue, of course, which anyone who's spent any time at the board is certainly quite familiar. I think there's a concept that I have had in mind for many years with regard to this, and that is the question: what are the premises for change? I mean, we are talking about administrative jurisprudence. When I went to law school a long time ago, Kenneth Gulp Davis was the Dean of Administrative Law. And I think there are some neutral principles that apply to administrative jurisprudence that seem to have been lost. And I'm not pointing fingers at Democrats or Republicans. I think what the chair said is exactly right. Some people have greater value or place greater value in stability. Others place greater value in an outcome, in a particular outcome. But what do I mean about what are the premises for change? Well, there were two things that we did when I came to the board that I'm particularly proud of, because I think that we tried to apply that principle of administrative jurisprudence. One was the DECLA decision with regard to pre-hire agreements in the construction industry. The other was bargaining units in healthcare, hospital bargaining units. In one case, we used a case with input from the public, as Lauren has indicated, to revise the rule with regard to pre-hire agreements. The premise for considering the change was the prior rule or rules in place were not working very well. The board was spending inordinate amounts of time determining whether or not so-called pre-hire agreements had converted to full agreements under the statute and so forth and so on. So we devised, and again, this is not to say that others may not reasonably disagree, but devised a rule which I think has some durability. Likewise, with regard to bargaining units in hospitals, this had been an ongoing problem. We have some former RDs who are in attendance today. They can validate this notion that the board spent inordinate amounts of time, so oftentimes months, litigating this issue of what is the appropriate number of bargaining units in a healthcare institution, given the caveats that were articulated at the time that the healthcare amendments were added to the statute. So I think that the short answer to your question is yes, it's likely to continue, and yes, rulemaking is likely, I think, to be more frequent or more common for the reasons that Lauren has suggested. But I would just remind people, I think, that there should be an administrative jurisprudence. There should be a premise for the change of the rule. It shouldn't be that I have a different view. It should be that the rule that's in place that's being administered is not working very well for one or a number of reasons. That's my view.
Thank you. Craig?
So at the risk of people thinking I always think in threes, let me say three things about this one as well. First of all, this is a function of the growing polarization of our politics, particularly our politics when it comes to the value of collective bargaining. But just look at the Supreme Court, with Janus being the prime example. Polarization leads to less respect for precedent, I think. One. Two, I hate the metaphor. I hate the pendulum. I hate oscillation, despite my great respect for Cindy Eslin, whose great article coined the term as applied to the board. When I was on the board, management lawyers wrote an article which argued that we reversed like 10 centuries of precedent or something like that. And I'm sure we could write the same article about the Trump board. But if I could give any advice to the incoming members, or what I hope will be the incoming members of the Biden board, is that they shouldn't read the trade press, except for Josh, of course, because What matters is the soundness of the policy that you articulate and your construction of the statute and what you put in to those volumes of the NLRB's decisions. So, my third point is it really doesn't matter. What's most important is certainly not reversing the last 4 years of precedent. That is certainly not what's most important, because we can look at those swings of the pendulum and we can see they've made no difference along any reasonable measure. They haven't really made any difference in terms of the board statistics, win rates, size of unions, number of petitions. They haven't made any difference in terms of how many people are represented or the success of collective bargaining. So to think that you're making progress, whichever side you're on, by reversing the last 4 years is certainly foolishness. What's important is to give life to the statute in today's context. So to merely try to swing the pendulum back, to use the metaphor, which I don't like, is surely a mistake.
Thank you. On that point, given the decline of collective bargaining, the limited remedies the board has for enforcing the law, and the spread of work arrangements like subcontracting, franchising, and independent contracting that complicate the question of the employer-employee relationship, how relevant is the NLRB to workers now in the United States? Starting with Chair McFerran.
I'm hoping you'll get the same answer to this question from everyone, and I see where the question is coming from. When I graduated from law school 20 years ago, a friend discouraged me from going into traditional labor law, saying it was not a growth field. But as we've discussed in the past, Josh, you and I have talked about this before, I think the Act could not be more relevant today. I actually do think that protected concerted activity, which is often a precursor for union activity, is a key part of this. Because the Act is protecting a worker's own activity, the Act is unique in its flexibility and its responsiveness to changing worker priorities and changing economic circumstances. Certainly, workers in the 1930s could not have imagined that the NLRA would be invoked by their 2020 counterparts to join together and demand personal protective equipment during a pandemic, to challenge the denial of employment protections in a gig economy, or to protest the silencing of harassment victims. But in my view, it is manifestly clear that the plain language of the law does protect this and more. The beauty of the Act is that essentially what workers care about is what the Act cares about, and that's what makes it relevant. And the breadth of the law's protections, the flexibility that was built into it, really does make it adaptive enough to respond to changes in the economy, changes in the nature of work. The way that people communicate can change. The way that we interact with each other can change. The way that employment relationships are structured can change. But the Act is flexible enough, and the basic principles of the Act accommodate those changes in the surrounding nature of work in the economy. Now, one thing that you have flagged in the past, I believe, is whether the Act has teeth or not. I think is something, and that's certainly something that I think can be very frustrating. The Act is relevant. The Act is has these important rights, and there's a significant question as to whether it has teeth. I do think that we sometimes see really egregious violations of the Act, particularly by repeat offenders. And I would say that every board member that I have worked with across the political spectrum is troubled by those situations. I hate the impression that there is a small subset of employers and respondents. I would say there's a small subset, but that there is a small subset who have simply decided that the consequences of refusing to comply with the law are doing business. And that the question of whether the Act should have different remedies that's a practical matter, largely an issue for the legislative branch at this point. But I have been an advocate, sometimes in a dissenting position, for the board making full use of the remedial authority that we do have available to us. My job as a board member is to apply the law as it is, not to speculate about what changes Congress should or should not make. But I would certainly be more than happy to consider making use of more extensive remedial tools were those to be available to us. And I think many past board members would probably agree with me about that.
Thank you. Marshall?
Well, I think I've already said that I believe that the statute and the agency remain relevant for many of the reasons that Lauren has suggested. I think that it's extremely important. I think that the practice and policy of collective bargaining is an important one. It is very, very significant in the day-to-day activities. I will say that there are issues that arise from time to time that pull at the extremes or the outer reaches of the statute. There are limitations, for example, I think, in some of the definitions that have been incorporated into the statute, or the common law definitions that have been adopted pursuant to the statute and Congress's direction. So, for example, a couple of years ago, I was asked to testify in the joint employer standard that the board was considering at the time. I think that there have been significant changes in the manner and the methods by which companies operate, by which our economy operates in this world market that we're dealing with, that I think properly could be considered by Congress with regard to the metes and bounds of the statute and whether or not we are providing protections and opportunities for people who otherwise might not be encompassed within the bounds of the NLRA as it's written now. Certainly our demand economy and the manner in which work is performed is changed significantly enough that it would not be irresponsible, it seems to me, for Congress to take up the cudgels on that. But that being said, I do believe that the statute is relevant. I believe that the concept is vital and necessary, both in the collective bargaining context and with regard to protected concerted activity. It really is when the system works, when an employer and a union are able to establish a mechanism for workplace democracy, it's really quite successful and can be very, very beneficial for all the parties who are concerned. So I would like to see the statute remain vital, and I would like people to be open-minded to considering making adjustments in those areas with regard to issues that may be at the margins of the statute.
Thank you. Craig?
Well, I certainly agree with my colleagues that the statute remains relevant. There's 14 million union members or workers represented for purposes of collective bargaining. Labor movement is certainly among the largest and most vibrant social movements in the country, and certainly the only one seeking to represent working people. So it's a very important statute, which is not to say that it doesn't have flaws, which should be corrected by Congress soon, and perhaps will be. But in terms of why the law may have become less relevant, and even there, there's been a slow drip in terms of union membership, but the last 30 years, the labor movement has really stayed fairly stable. Very slow loss of membership, but nothing like the 70s and the 80s. So the act remains certainly relevant for all those and those who are trying to organize in unusual places, Amazon in Alabama versus recently in North Carolina successfully. But in terms of what are problems with the act, I tend to think that the whole notion of fissuring, with all due respect to David Weil, who's also going to have his confirmation hearing as wage and hour administrator along with the 2 board nominees, is somewhat exaggerated. I think Uber and Lyft and McDonald's, in terms of its franchise relationship, have caught a lot of public attention. But when we filed our comments on the joint employer rulemaking, we actually went and looked at all the joint employer cases the board has considered in some period of time, last 10 or 20 years, I want to say, and there's been very few, and none of them had been affected by the board standard. That is, all of them were clear cases under any standard. So I wouldn't exaggerate the importance of fissuring. What I would exaggerate is the precarious nature of employment in general. It is globalization, the end of career employment, the increasing distance between owners and workers, all of that has led to American workers feeling that their employment is more precarious and therefore being scared to exercise their rights under the Act. So I think there's a broader set of forces at work which really do make it hard for people to exercise their rights without assurance of timely and adequate remedies. Let me stop there.
Thank you. To the question further of the board's authority, last month in its Cedar Point case, the Supreme Court rejected California's decades-old regulation letting union organizers visit agricultural workplaces. This case involves farm workers who are excluded from the NLRA and union access to non-union workplaces, which is already quite limited under the NLRA. But the majority opinion takes an approach to property rights and regulation that could have broader implications. So does that case put any current or future exercises of NLRB authority at risk? Starting again with Chair McFerran.
And I apologize, I'm largely going to have to punt on this question. The short answer is that it's hard to know. It seems likely that in access cases involving unions as opposed to employees, the board could well get arguments based on Cedar Point. So for that reason, I am going to decline to comment, other than to say that the court seemed to take great care to distinguish access issues presented under the NLRA from the issue addressed in Cedar Point. But other than that, I don't know that it is appropriate for me to comment because these are issues that could come before the board.
I will hand all of your time then to Marshall.
So I just want, I know everybody who's listening understands that I'm exercising some measure of restraint every time that Craig refers to the outcome at Amazon, which I believe is still the subject of litigation at the NLRB. So even though I'm not involved and my firm is not involved in that case, my recollection is, I don't have the numbers in front of me, but the numbers were quite large in terms of not favoring representation. And so we'll just have to see whether any of the issues that Craig flagged for us end up being pertinent or not to that particular outcome. Cedar Point is interesting. I first started practicing law out of law school in California in 1975 when the Act was became effective, and this access provision has been controversial from the get-go. I mean, there's no question that it has. The Chief Justice who wrote the majority opinion, I think, was quite adamant in his view, along with his colleagues, with regard to this being a taking. There was discussion of, as we know, of Babcock and Wilcox and Lechmere. In one case, Lechmere, although really wasn't discussed in any great detail in the Chief's majority opinion, Lechmere, of course, was a shopping plaza. I mean, it was everybody in the public was invited to that particular location, and we understand Justice Thomas's opinion in that case to be quite limiting with regard to access. I thought it was interesting that Justice Kavanaugh wrote a very brief concurrence in which he really only discussed Babcock and Wilcox, and he thought that the result in Cedar Point was in fact dictated by the court's decision in Babcock and Wilcox. I think if one looks carefully at what the Chief Justice wrote in the majority opinion, particularly his characterization of the facts in Babcock as being highly contingent, he uses that term, I believe, highly contingent facts, which I take to be the prescription that there is no other access available to the individuals. I think that people might well be concerned that this Supreme Court majority would take a narrow view of a union's right of access to employees and to an employer's property, private property, particularly if it's not in a public setting like Prune Yard or Leechmere, and particularly if the individuals do not reside or remain on that private property for the duration of their employment, such as in the lumber camp cases or the barge cases that we considered when I was at the board. So, we are dealing with a conservative court, and I think one should not be surprised by the position that they took.
Thank you. Craig? I know you worked on briefing in this case as well.
Yeah, we filed a brief. Picking up where Marshall left off, we were not surprised, unfortunately. But I do think before talking about the implications for the NLRA, it is important to recognize just the extraordinarily formalistic mode of analysis engaged in by the board. Here you had a highly contingent right. This was not a right generally to wander around the farm at any time. This was a right which the union had to petition for, which was limited to non-work areas during non-work time, and were only a certain number of days related to the organizing activity, and which was limited solely to communications related to the organizing. So the California Agricultural Labor Relations Board, for example, has held can't even get access to examine safety practices on the farm. It's limited to the representation process because of the difficulties of organizing in that industry. And the court takes a highly formalistic analysis and says there's essentially an absolute right to exclude others. You're intruding this teeny little bit into that, and therefore it's a taking. But turning to the NLRA implications, I do think they're going to be limited for reasons really Marshall already pointed out. That is, the majority expressly distinguished Babcock and Wilcox. In fact, again, as Marshall pointed out, Justice Kavanaugh wrote separately for the sole purpose of distinguishing Babcock and Wilcox, which he called a quote necessity exception to the takings clause. Second, honestly, Babcock and Wilcox is so narrow already that I don't know if any of us could identify any cases where the board has said there's a right to access under Babcock and Wilcox and Lechmere. So, it's not clear that it would be a great threat if it was knocked out, although it would certainly be unfortunate. The court also expressly distinguished the California Supreme Court decision in Prune Yard and the Supreme Court's own affirmance of Prune Yard under the takings or against the takings challenge. That is the right under the California Constitution to go on to a shopping center and engage in expressive activity. So as to similar types of situations under the Act, for example, shopping center lets on various types of third parties, but won't let the union on. So there's a discrimination claim that would seem to be preserved by that analysis. But honestly, it's not hard to imagine creative management lawyers thinking up some applications. For example, the board's doctrine on off-duty employees, access to the facility, or off-duty employees from a different facility, access to the facility. Again, I think it would be a stretch. That is, those are cases regulating the employer-employee relationship and not granting access by some third party, as was the case in Cedar Point. The other thing I would say, and it was pointed out by a good friend and colleague of mine from California, Glenn Rothner, who started his career with the UFW and now has his own firm in Southern California. What's the compensation? So what's the value of walking down this dusty road to the field and standing there for 5 minutes talking to workers? So all they held is you have to provide just compensation. That's not a very valuable taking, not a very valuable piece of the employer's property that's been taken, even if you could see that something has been taken. So it's not clear that there's not a fairly easy legislative fix there. Let me stop there.
Thank you very much. Something else that I know Craig is interested in talking about is the long-term legacy of the Trump NLRB. How many of their precedents will stay with us? Will we be living with these precedents for a long time? Will those regulations stay on the books? Will there be a new era of the rulemaking authority being used more frequently, and should they? And also, will the sorts of ethics controversies that we saw characterize that board be repeated in the future? Again, I'll start with Chair McFerran.
I'll start with the rulemaking piece of that question, and I would like to comment on the ethics point as well. And obviously, in terms of substantive priorities, it's impossible to say because there aren't any new board members yet. Personally, in terms of the notion of a shift to rulemaking more generally, I think that's one possible legacy, if for no other reason than the board had not previously flexed that muscle much before. And once we've done it, it's a process that becomes easier to do. Expressing only my personal perspective, I like rulemaking in theory. I find it interesting. I'm the child of an administrative law professor. I'm a big believer in the benefits of the APA rulemaking process. It just happens to be the case that I would have used rulemaking in totally different circumstances than the current majority did. And there are certainly kind of pros and cons to rulemaking that one would have to bear in mind in considering whether it is a way that the board should do business more often. It is true that rulemaking can address a topic more comprehensively than a single case adjudication, where at least in theory, the decision is only supposed to address the questions necessary to decide the case. As I mentioned previously, I think it's problematic to use a single case with a single issue as kind of a jumping off point to make broad board law without any notice to the public or opportunity to weigh in. I mean, that's another, of course, of the significant benefits of rulemaking is greater public input. As I said previously, again, kind of one of my frequently expressed disagreements with the current board is the failure to seek public input. There were many reversals of precedent that were completely unbriefed. Rulemaking certainly provides a guaranteed opportunity for the public to weigh in, and that's beneficial. But the experience we've had over the last few years also indicates that there are some drawbacks to rulemaking. Rulemaking done right is incredibly time-consuming and resource-intensive. Drafting an NPRM, conducting the required regulatory analyses, processing comments, responding to comments, this takes a lot of manpower, particularly at an agency like ours that is currently statutorily barred from employing people who conduct economic analysis. That's not to say it isn't doable. We have incredibly talented people at the board, but there are trade-offs. Every staff attorney who's devoting time to processing and responding to comments is a staff attorney that's not writing bench memos or drafting decisions. And when, as Marshall mentioned, I believe previously, case processing efficiency and expediency is and should be a priority for the board. So that is a competing consideration there. Rulemakings, of course, also give you a lot more ways to trip up in the courts. Essentially, all major rulemakings at an agency like ours are going to end up getting challenged in court. And even when you've done your homework and you've really taken your time, there's a lot of potential landmines. So I think rulemaking could be a useful tool, but only when used in carefully chosen and appropriate circumstances, and only when done with the requisite care and attention. Also, and I want to be clear here, I don't think rules are a substitute for adjudication or will displace adjudication as the agency's primary way of doing business. In my experience, unfair labor practice cases are unique and they're fact specific, and the application of law to fact, even if there were regulatory guidance in place, requires careful scrutiny. So I think even if a future board were to decide to make some rules, we will still spend most of our time deciding cases. Now you raised the question of, whether the board will continue. How did you phrase the question about ethics, Josh?
Will we see more of the sorts of ethics controversies that we saw over the past several years at the board?
I think it's important to understand that historically speaking, ethics controversies have been extremely rare at the board. Highbrand triggered a great deal of controversy in and outside the board, and even led to an in-depth internal review of how ethics issues are handled by the agency. I don't want to revisit those agreements or disagreements today. I've expressed my views in the several Highbrand decisions and dissents that I've written, and in addressing in my separate statement the ethics report issued by then Chairman Ring. What is important to remember is that Highbrand was an incredibly unusual situation, stemming from basically the wholesale incorporation of a dissenting opinion from a prior case that was still pending in the Court of Appeals into a new majority opinion in a different case, almost word for word, including explicit adjudication of the outcome of the prior case. I think it's safe to say that specific sequence of events is unlikely to recur in the future. Of course, like all government agencies, the board is highly scrutinized in matters of ethics, and I think properly should be. The board as an institution, though, is conscientious and sensitive about these things. And we have a strong internal ethics office. Again, if you look at history, generally the board's decisions when we've had to handle these types of issues have been upheld when challenged in the courts of appeals. There's no reason to think that complicated ethics issues are going to become a recurring theme at the board. They haven't really been in the past until very recently. And unless people attempt to generate problems for their own strategic reasons, I don't see why there would be in the future.
Thank you. Marshall?
Well, I certainly agree with the comments that have been made with regard to rulemaking. I think that there are advantages. It certainly is time consuming. It does consume a lot of resources. There are appropriate instances in which it's appropriate. It provides opportunity for input from a large number of parties. And I think it can be very worthwhile in terms of the durability of the rule. I do agree that just because of the process itself, that it's not something that's as subject to willy-nilly overturn as a case-made rule may be. But it still is subject to overturn, and I would still argue, as I stated earlier, that there should be a premise for a change in any rule, whether it's by one political group or another. Certainly what Craig said about our being in a highly partisan time, that clearly is the case. And I think that applies, Josh, somewhat to the question that you ask about ethics inquiries. We all should want to have people at the agency in these appointed positions, whether it's the general counsel position or the board member seats, who have some experience and background in the statute. I mean, I think it's very, very valuable. I think, unfortunately, as Craig was suggesting, that we live in a time where partisanship is such a hardy element in our day-to-day lives that some of that there may be people on the sidelines willing to hurl some pineapples in the ethics arena because we may have board members who come from one union or another that have been involved in a lot of cases and so forth and so on. During the time that I was at the board, I think all the board members took the prescriptions seriously. I would not, even though I was in a labor law firm prior to my coming to the board, I certainly wouldn't participate in any decision or any case that was remotely related to my law firm or to prior clients of mine or my law firm. And I think those are, good rules to abide by. So with regard to whether or not this past board's writings and policies and rules will have any more durability than others, I think, as Craig has suggested, we're living in a time where people are going to be exercising their prerogatives to make policy choices, and I would expect that to continue.
Thank you. Craig?
Okay, so this time, Josh, you've given me 3 parts, so let me take them on one by one. As to the Trump
Not
board's
3 times 3?
No. My time is running out. I didn't get any of Lauren's extra time. As to the Trump board's legacy, I don't want to be a flip, but I think the legacy is going to be aptly characterized by the aphorism, haste makes waste. And I think that started right from the beginning with what we in the labor movement call the Miscamara massacre. That is a rush to get decisions out at the end of the former chairman's term, which led to the whole high brand problem, quite frankly. and led to the board having to overturn its own decision in IBRAM. But it continued in the two central rulemaking proceedings. So the central rulemaking procedure, the revision of the R case rules, was done without notice and comment. For all the reasons Lauren has eloquently articulated, why in the world would any agency do that? You've essentially taken out the very reason for rulemaking by not allowing notice and comment. And the district court has already struck down the heart of that rule. For that reason, I'm quite confident the Court of Appeals will affirm. The case has been argued and is under consideration. But the same is true for their tripartite rule on blocking charges, etc. There were gross factual errors in the data presented in the notice of proposed rulemaking. Lauren's dissent outlined them in detail. I'm sure the majority had a chance to review that dissent, and it chose just to plow ahead and present grossly false data. Why in the world would they do that? Why in the world would they do that? We have that rule-making proceeding under challenge in the district court. It stayed awaiting a jurisdictional ruling in the first case. But I'm quite confident there again, the rule is going to be struck down for that reason and others. The joint employer rule, clearly inconsistent in some ways with the District of Columbia Circuit's decision in Browning-Ferris. I'm quite confident that rule cannot survive, as well as the court may make clear in Browning-Ferris, which is now back up for the court after remand and two decisions by the board, which made every effort to avoid the first Browning-Ferris decision in the Court of Appeals. So I think their haste is going to lay waste to much of their legacy. In terms of rulemaking, as Lauren has said, both the Obama board and the Trump board flexed the muscle. I think it got a little bit cramped under the Trump board, but the capacity is there, but it should be used properly and with deliberation and in the right circumstances. And it's not always the right circumstance. I think the board, in the student worker context, I don't know why they withdrew the notice of proposed rulemaking, but I would guess that they decided this is an issue better addressed on a case-by-case basis. It's hard to make an across-the-board rule, and the situation is different in many instances. So I think rulemaking is appropriate if done properly when there's an across-the-board policy issue to be addressed. As to ethics, I'll be very short, which is I'm very, very confident that that Lauren and the Biden nominees will be absolutely scrupulous in terms of their fidelity to the rules of ethics, and I think it'll be a non-issue.
Thank you very much. We have about 1 minute each left. If Chairman McFerran, is there anything you'd like to respond to or elaborate? You're muted.
This has been a very interesting and a very lively discussion.
Thank you. Marshall, anything you would like to expound or respond to?
I would just echo the comments. I think that this will be an interesting time as we move forward. I look forward to a revitalized and fully staffed NLRB, and I'm sure that we will continue to have policy discussions, if I can use that term loosely, with regard to a variety of things. As everybody on this webinar is aware, we have some pending legislation. I believe there's a hearing scheduled for next week. There are some important changes that are being discussed with regard to this statute, which will have an impact on everyone. I'll leave to another day discussion of the jits and jots of that sweeping proposal.
Thank you. And Craig, would you like to rebut or elaborate anything from the past hour?
Not rebut at all. I think Marshall and Lauren would agree with me. I hope they would. That one of the things that's really wonderful about being a board member is that you're not a Supreme Court justice and you're not a judge, and you don't have to pretend, like Justice Roberts said in his confirmation hearing, that he's just calling balls and strikes. We all know that that's not true. And the beauty of being a board member is that the Supreme Court said it's okay for you to set wise policy in those gaps in the statute that Congress has allowed, as long as you do it honestly. And so I think this board will establish new policy, and I'm confident and I hope that they'll do it in a forthright and honest manner and address the real problems that exist under this statute. So thank you all. It's been a pleasure.
Thanks so much. I'm grateful for the time and wisdom and insight of these panelists, and to our audience and to LERA. And please, wherever you may work, feel free to reach out to me about what's happening in your workplace. Looking forward to being in touch with each of you in the future. Thank you very much.